We acknowledge that the land upon which we gather is unceded Mi'kmaq territory. Etobicoke is covered by the historic treaties of peace and friendship. We pay our respects to the indigenous Mi'kmaq people who have occupied this island for over 12,000 years, past, present, and future. And if I take the attendance, the Deputy Mayor Jason Cody's here. I'll just start from your right, my left. There's Councillor McCabe, Julie McCabe, Councillor Alana Yankoff, Deputy Mayor Cody, Councillor Tweel, to my right and to your left, Councillor Terry McLeod, who is the Chair of Planning, Development and Heritage, Councillor Mike Duffy, and Councillor Ramsey, and I have Councillor Terry Bernard had another function on this evening. Any word from Councillor Bob Duran? Did he call in? No. Is he WebExed in? Okay. And thank you. Councillor Rivard is out of province, so he's not here tonight, so we're missing 3. Planning board members, I see Bob Kenny, he's in the audience. Basil Hamley is live streaming by YouTube. Chris Fournier, no response from Chris. Paul Connolly's not here. Rosemary Habert is coming in by WebEx, and Shaylin Murray, she's also streaming in by WebEx. So we do have, as I look at the agenda, I'm going to turn it over to Councillor McLeod, and as I said, this is called to order. Any declarations of conflict of interest? Seeing none. On the agenda, approval of agenda, we have 4A, zoning and development bylaw. Amendments, we have more than several sections to amend. Do I have a mover? Moved by Councillor Ramsey, second by Councillor Tweel. All those in favor? Okay. So I'll turn it over to Councillor Terry McLeod, and he can start it off, please. And I'll give you this right here, sir.
Thank you very much, Mr. Mayor, and welcome everyone to tonight's event here. So I'm just going to give an order of the event presentation. There will be a brief presentation first by staff on each of the items. After the presentation, the general public will be given an opportunity to speak. Each participant will be provided to 5 minutes in which to provide their comments or to ask their questions. We'll start with members of the public in the room first, and then proceed to those on WebEx that are streaming in. Council members will be allowed to ask questions of clarity. Remember not to give their opinion on the projects, as they are to remain neutral until the process is complete. Some reminders, just to show respect and decorum to all participants. Refrain from unmuting your devices unless you are asked to speak. When asked to speak, please make sure you speak clearly so all participants can hear your comments. Written submissions must be received on or before 12 p.m. on Wednesday, June 1st. That's tomorrow. With that, I would like to offer my thanks for the many residents who are here tonight and also streaming live. And now I'll ask the mayor, the chair, to call our meeting to order, which you've already done. Thank you very much, Mr. Mayor.
Thank you. And just to follow up with the COVID-19 protocol, Prince Edward Island is currently in step 3 of the transition plan to living and adapting with COVID-19. Public health guidance indicates that the province is moving from population health measures and restrictions to a situation where individuals will assess their own risk based on a number of factors, including their own health and vaccine status, and that of others, and the type of activity or event they are attending. Therefore, we are back in person, and some are streaming through WebEx at this time. In addition, residents will have the option to participate via video conference. So do we have anyone in line? Okay, so it's just the residents here. And all our meetings are live streamed on YouTube. So if you missed something tonight, just go to YouTube and search City of Charlottetown, and you'll catch the taping or the live stream of this meeting. So do we turn it over to Mr. Forbes?
Mr. Forbes, it is.
Mr. Forbes, Manager of Planning, Development, and Heritage. Thank you, Mr. Forbes.
Thank you, Your Worship. I'll just give at a high level the amendments that we're going to discuss this evening. So Section 3.3 of the zoning bylaw, development and building permits, housekeeping amendments to add a missing word. Section 3.1.5 reconsideration process to repeal the overall reconsideration process. Section 5.9 home occupations, clarify the definition of the proprietor of a home occupation. Section 8.1 zone table, housekeeping amendment to fix the numbering of the zone table. Section 35, water lot amendments, minor changes to the recently approved regulations that were developed to deal with the development on water lots. Section 47.2, election signs, align the requirements of the 3 levels of government as to when election signs can be erected. Section 48.3, subdivision requirements, housekeeping amendments to increase the required copies of proposed subdivision plans and clarify notification requirements for lot consolidations of R3 and R4 lots. Appendix A, definition of terms, housekeeping amendment for the definition of building, and Appendix F, fee schedule, housekeeping amendments to align fee schedule references to fees by law. So again, in regard to amendments to Section 35, which is dealing with water lots, there were some minor changes that came out of there was a temporary use that was applied for by the major provider of the floating docks on the waterfront. They came forward in April. They needed to get an approval to get up and operational. These longer-term amendments hadn't been approved by the province back in April, but they have subsequently been approved. But when we were dealing with their temporary use application, we did notice that there was a couple of we did realize that there was some additional information that was provided by the applicant, as well as getting them up for their temporary use approval this year. We saw where we could clarify the definitions of water lots. The issue is when we dealt with this last year to get the permanent amendments for dealing with those that want to do things on water lots was the coming in with references to how do we deal with the buildings that are sitting on top of those floating structures. And initially we had some reference to occupancy permit, some references to the building permit, but again, we subsequently determined that we shouldn't be using any references to the building code because the building code does not apply to anything that's floating. But at the time we made these amendments, so those are the only tools we knew. An occupancy permit is always sort of the last part of a building permit. So really what we did is we just took out a lot of those references dealing with building code, building references, occupancy permit, and we put it into the terminology of a development permit. Planners deal with development permits, and those permits have conditions. So all of the conditions that are on the temporary water lot approvals that are down there now, it's really for planning staff to ensure that they are being adhered to, and the building inspectors are not involved. So I'll go through some of them in a second. I think I've went through that part. Alan thinks that I can read what's on there, but I need to find my original report to go through exactly what transpired there. So the actual amendments that we dealt with for the water lots. You'll see it's hard to see on the reference, it may be larger up on the screen, but in the original report, we just went back into the regulations, which was attachment A of the report that came forward previously on this in May, and just indicated, again, under the section 35, before an occupancy permit that gets scratched out and put in the development permit. The next section is dealing with development permit. There was in the original amendments that the maximum number of floating floating homes, a float home, would be 3. And since that time, since we've been dealing with the applicant, we thought there was only 3 down there initially. There's actually 4. So in light of that, we just changed the terminology. We don't want a whole lot of floating, those floating homes or, floating commercial entities down there on the waterfront. But the fact is that the applicant who will be coming forward did have 4. So we just put in the reference that a maximum of 3 in case another vendor comes through. But if you had more than 3 at the time of passing of the bylaw, we would consider that. The other issue and the first amendments where we were fairly definitive about these units coming out of the water and talking to CADC and a lot of other people that are dealing with structures down there. Most of them don't come out of the water, but that will be a part of your decision making when somebody comes through with a permanent approval, whether they have to remove the, particularly it's the floating cottages. They need to be removed from the site, but again, in conversations with the applicants that are down there, they have been remaining in the water year after year. So instead of that they have to be removed, it will be a part of that application. You folks will be a part of some of that determination. The other sections. It's just providing a little bit more detail in regard to what is on the floating structure, accurate dimensions of the dock, so that we're very, that these docks are not incrementally increasing every year with more buildings on them. Under section F, photographs and renderings of the proposed floating structure, including all developments contained therein. Some direction to a qualified engineer in regard to what we need from them in regard to the floating dock. The load capacities, we're indicating what the engineer should be providing to us to validate that everything is correct there. And I think that's pretty well it on the floating. And the only other thing was when we came in with the amendments last year, we also changed the definition of building to indicate if a building was over water. But again, because it's a building over water, building inspectors don't deal with buildings over water. So we just brought the old definition of building back to its previous state, which dealt with buildings that are affixed to the ground. So those are those amendments. So maybe I'll break it up to the council. If you have any specific questions on water lots, I will answer them. And just so that you realize that the people that are utilizing those water lots this year are on a temporary use approval that expires at the end of the season. So they have to come in to you folks in the interim for their permanent approval. And this is really sort of tidying up their requirements when they come in for their permanent approval. So thank you, Your Worship.
Alex, thank you. Councillor Duran is now coming through to us in WebEx. So before we open the floor to comments or questions, just a reminder that each speaker will be given 5 minutes, and we do have a timer here so that we allow speakers or presenters the time to express their opinion. And since this is a public meeting, we ask that before speaking, please give your name. If you wish to, give us your address, your street, or where you're from, Charlottetown, Winslow, North Winslow, but again, please provide at least the bare minimum information. And we have the mic here in the center of the room. And again, those joining via WebEx, and I don't think we have any, you can just call your name to speak, and our technical staff will request that you unmute your mic before providing any comments. And we'll open it up. So you're going to stay there, Alex?
Yeah, you may just want to ask if, because I have other amendments, but you just may want to ask if anybody wants to speak directly to water lots.
Yeah, and if you did get a copy of the report, it was on the front desk. It's on page 8 and 9. So if you do wish to ask any comments or ask any questions or make comments about section 35.
Correct, yep.
Water lot amendments.
So if there's no questions on that, then I'll move to the next set of amendments.
Go ahead, sir.
So section 3.15 reconsideration. This was a fairly lengthy component of the zoning bylaw, and which basically allows an aggrieved person to ask council to reconsider any approval that we deal with. So this issue has come up on numerous occasions before. We've had a number of applications for reconsideration. We've talked about this at the planning committee. We've talked about the utility of keeping it, and so, again, because we constantly are doing these amendments, in the past, it was always, well, we don't want to do one while we're in the middle of a reconsideration. But in this case, this is one of those items that we just need to discuss. So just before I get going too far on it, though, there is a reconsideration request in currently, which will be honored and respected. This won't impact that one, but it's just a matter of the reason that staff are asking for this to be removed is that in my mind, it's somewhat redundant. It's not a requirement of the act. It was unique to Charlottetown, and it was put in to somewhat protect the municipality in the event that somebody went to Iraq, and if it was determined very quickly that the city made a mistake, that the city could unwind their mistake before having to go through that much more lengthy Iraq appeal. We've had a number of these cases where we've dealt with reconsideration. Since in my time here, staff have never recommended, it's a two-part process. The first part is, yep, there's a threshold test as to whether it should even be reconsidered by council, and then council will make a determination. So we tried to compile a list. Councillor Cody asked how many of them that we dealt with, and I sort of deal with sort of my time frame when I was here. And do we have the list of the ones that we dealt with? Right. Well, you don't need to show it. So Ellen prepared. She's getting a spreadsheet.
Do you have a number? How many? 10 since 19.
Right, but
Since amalgamation.
Well, 10 are the ones that Ellen and I could reference.
Last 3 years.
Right.
Okay.
But then we were waiting for Laurel. Laurel has got a list of 23. But these things, the reason that we're asking that it be taken out of the bylaw is that it's a duplication of the IRAC process. Just for your benefit, we had a reconsideration recently. We were at appeal last week. Laurel and I were there for 3 days. The lawyers were there this morning. That record was 1,000 pages, 1,000 pages at IRAC. I wrote an 11-page response to the reconsideration on that application. So these things are incredibly time-consuming, and then in a lot of cases they're putting planning staff in the position of being lawyers. So we're now moving into the legal realm, and the other thing too that I would caution you is we're getting more and more pushback from developers on threats for lawsuits for delays in the development process. So we're keeping them at bay. But so I'm not the lawyer. I've been working with David on this. There was a reason why that this was put into the bylaw. I think it was well intentioned at the time. It's just not really worked to the extent that it should. The other thing that's happened at IRAC recently is they've introduced a new process called mediation. So what happens if you go to IRAC and through our lawyers, if they sense that somebody has some kind of an issue, and it's all basically on process. IRAC is about process. It's not the decision you make, whether it's right or wrong, it's the way you make the decision. So if you deviate from the process, there's a flag on the field, and it will likely come back to you. So if we go to IRAC, and at the early stages, if they don't come right out and say it, but if they sense that there is an issue in the way that the decision making was accommodated, they will somewhat telegraph, you may want to go to mediation on this. We can work it out with the applicant in regard to coming up with some kind of a solution. So that's a new methodology that we didn't have in the past. I think it can replace this process. And again, and every time there's a reconsideration, it delays the IRAC process. So it extends the decision-making as to when, the public can find out what is the end result on their request for whether it's reconsideration or going to IRAC. So those are the reasons and rationale. When I come back to Planning Board and Council, we will try to get as comprehensive a list as we can in regard to over the years that, Laurel Palmer Thompson's been here the last 20 years. But I was actually surprised at how many times reconsideration has been employed in the past. So that's the reason and rationale, Your Worship. This hasn't just come up recently. This has come up on numerous occasions in regard to whether it was achieving its intended purpose. And staff are suggesting that the IRAC process is fulsome, comprehensive. Like I say, 3-day review on one application. You cannot sort of, if there's a problem in the process, it will be ferreted out at the IRAC appeal process. So, the citizens' interests are protected there. So
Just to clarify, so is that 23 plus the 10? That's 23 altogether over the last 20 years?
I think it's, I have the list here, Laurel's got 23 and we've got 1, 2, 3, 4, 5, 6 that she pointed out in the last 3 years, or 7 actually, and she had one on her list. So it's somewhere like 25, 28 of these, and she didn't know whether she caught all of them because you just can't go into an electronic record and just say, where did we deal with the reconsiderations? You have to kind of go back in and manually go through those files. But at any rate, there's a lot of staff time that goes into those, and they're detailed. And again, for the most part, in my time, we've never recommended it should go to the second stage.
Okay, so we'll open the floor up for the amendment to section 3.15 reconsideration process. So if you wish to, just please come to the mic, give your name, want to give your address or just your municipality. Thank you.
Is it okay to take my mask off?
Yes.
I'm Janet Roach. I live in the Winslow area of Charlottetown. And I have something prepared here I'd like to read.
Go ahead. Thank you.
I am against the repeal of section 3.15 reconsideration process. Our neighborhood of Highfield Heights has recently filed an official letter of reconsideration and a petition, which was presented to the mayor's office on May 16th, 2022. We filed this reconsideration due to the fact that a new subdivision, Hidden Valley, is being built as an extension to our existing Highfield Heights subdivision. Our neighborhood is extremely concerned about safety and the substantial increased traffic flow of roughly 300%, going from approximately 190 vehicles per day to a total estimate of 762 vehicles per day, using only the 2 existing entrances and exits. There is clear doubt as to the correctness of the decision on the first instance. The residents of Highfield Heights are asking the mayor and city council for reconsideration due to the lack of a traffic study, failure to follow the bylaws and the official plan, and failure to follow sound planning principles. The reconstruction bylaw was the only bylaw we had available to us in order to make our views known and press for change. The 2021-22 annual report message from the mayor spoke to the continued focus on creating an open, transparent, and accountable city hall. There must be an avenue for the citizens of Charlottetown to make sure that their views and concerns will be taken seriously and to not just be told it's met all the requirements, in our case, without telling us what those requirements are or how they have come to make those decisions. City Council should advocate for our interests and concerns. The employees of the City of Charlottetown work for all citizens of Charlottetown to help make our city better. Not only do I feel that the reconsideration process should stay in place, I feel that there should be more added to this bylaw to make sure that those that make the decisions are held accountable, that processes are more transparent, and that timeframes need to be absolute. There is no time frame listed there at all, so it could be anything. Better communication is in dire need of improvement. For the city to post notice on their website of the approval of any permit or subdivision and deem this to be notification under the bylaw of a permit being issued is wrong. As an example, the citizens of Highfield Heights only found out about the new subdivision with 143 new duplex lots when the sign was posted on the land by the developers. But a neighbor received a letter from the city of Charlottetown advising him that one of his neighbors had planned to build a garage and was asking for his concerns or comments he would like to make prior to the permit being approved. How is it that a letter can be sent to advise about a garage, but no notification is necessary for a whole new subdivision? To tell the citizens of Charlottetown that that is the way things work is also wrong. This is not how it should work and needs to be changed. As long as these types of contradictions are happening, then we need to indeed keep the reconsideration bylaw in place. There must be an avenue for the citizens of Charlottetown to have their concerns known in the official process. Thank you.
Thank you. Mr. Forbes, would you like to respond?
Just that we will be hearing this particular reconsideration because it was in before that this was brought forward. But I guess in regard to the concerns, that's what the IRAC process is there. They're allowed to appeal this to IRAC, which is again much more rigorous in regard to reviewing these things. They are lawyers, and then they're in a much better position to provide direction to council as well. They're a third party to everyone. So in the future, this one will be dealt with through the council, through the reconsideration process. There is an appeal on the same subdivision, so it'll be going to IRAC. So the bases, in my humble opinion, are covered in regard to, the citizens have recourse to have this decision-making reviewed, and it will be reviewed in detail. And as I say, they don't leave any stone uncovered when they do a review.
So just to clarify, Alex, there's an appeal with IRAC on this subdivision, and then we have a reconsideration.
Right, and I will follow up with Ms. Roach tomorrow because I was following up, and again, this is why there's a bit of confusion. There was somebody else, it's usually the same person that asked for the reconsideration and the appeal. In this case, they're different. So again, I'll follow up with Mrs. Roach tomorrow in regard to the reconsideration process that she will follow or work with us to bring forward to you folks. But there is an IRAC appeal, which I only received yesterday. I think yesterday on that this actual subdivision was under appeal.
Yes, you coming up on 3-1? Yeah, you got it.
My name is Jerry Wolfrey. I'm a resident of Southview Estates in West Royalty. And I'd like to give a shout out to the Charlottetown Islanders who advanced to the Quebec Major Junior Hockey League Finals last night. Good news, and we're pretty proud of the boys. So our reconsideration process that planning staff now wants to repeal proved successful for not only the residents of Southview Estates last year, but for council as well. It empowered them to correct their decision that was based on inaccurate, outdated, and missing information. The process worked exactly as intended. The reconsideration process is not a procedural flaw remedy, as suggested. It is clearly the decision that may be reconsidered by council. Section 315.3 further elaborates on the intent of the reconsideration process by stating that council may review, rescind, change, or vary any order or decision. And listen carefully to this, made by the development officer or by council. So why is that important? One word, and it was brought up already. Accountability. It makes the development officer and his staff accountable for our elected, or to our elected council. It also provides council with legal authority to review, rescind, change, or vary an order or a decision made by the development officer. Is that who wants the section repealed? I submit that such authority bestowed on our elected council is pretty important in a democracy, where a resident or a business can demonstrate that an order affecting them was unjustified. Why in tarnation would council want to surrender that authority? Or the authority to reconsider their own orders and decisions for that matter? That authority is an important tool in responsible self-governance, and accountability is a crucial part of good governance. IRAC is not part of our municipal self-government structure. IRAC is an adjudicative body. It's a legal process. It's expensive and is cost prohibitive for many residents of our city. Yes, it can be an option for some, but not for many. The city must incur significant costs in that legal process too, taxpayer-funded costs. And what about IRAC decisions? Do they align with the policies and goals of the city of Charlottetown? Sometimes, perhaps. But I submit that council has much more decision-making flexibility within the reconsideration process. Self-governance. IRAC does not represent our citizens. Our elected councillors living in wards throughout the city do. Democracy is important. Accountability is important. Self-governance is important. And the reconsideration process as it exists is an important tool for maintaining all three of those. So what is the motive here? Is the department understaffed? If so, that might be what needs fixing. We all need to have confidence in our planning department, but we're all human and mistakes happen, especially if we're overworked. When mistakes happen or material facts are unknown at the time of a decision or the granting of an order, then the reconsideration process provides a redress mechanism to council, residents, and business. Reconsideration is not a given. Applicants for reconsideration under 315 must meet a very specific legal threshold. And even then, council can decide if the application merits reconsideration. If not, that is the end of the matter. So that administrative control is already built into the legislation. That is why reconsideration by council is a rarity. However, it is an important avenue for civic redress in cases where normal procedure fails. In the Southview Estates example, the reconsideration process provided residents with their only opportunity for input into a decision that would have had a profound impact on the health and safety of our residents. The only opportunity. We had no notice of the commercial zone lot amalgamation and the associated development plan until after council issued the order. And that was because a previous change to our zoning bylaw removed the requirement to notify nearby residents in cases of as-of-right development. So the reconsideration legislation in section 315 of our zoning bylaw provided our first opportunity to address council on that application. And now, planning staff wants to deny that one opportunity to participate in the civic process. That is not how the democratic process is supposed to work. The reconsideration process gave our residents a voice. Council was able to review our presentations, and Section 315 provided them with the authority to overturn their initial decision. Again, the process worked as envisioned. It is not broken. It does not need fixing, and it must not be repealed. But thank you for the opportunity of addressing.
Thank you, Jerry.
Thank you.
Thank you very much. So if you have your package, it's on page 11, attachment B for the reconsideration and what's going to be removed. Mr. Forbes?
Look, I mean, that's why we're having a public meeting here tonight, and by all means, we respect, the commentary that comes in. But I guess I have to remind council that in the case of Traynor Street, whatever decision you make, if the developer had taken you to IRAC, you're in the exact same position. They're going to review everything, and then they're going to review the reconsideration process, and then they're going to rule whether you had the legislative and legal authority to do what you did. And the fact that this is all laid out in the Community Planning Act. So again, in my humble opinion, IRAC, who I just cannot tell you how thorough they are to review everything. They are the better body to deal with this because they understand the Community Planning Act. They understand what you're empowered to do and what you're not empowered to do. So again, I respect the Mr. Wolfrey's commentary. That's for you to deal with, but there. Everything can go to IRAC. So it's both sides can go to IRAC and they will rule. And my job is to ensure that your decision making is as sound as it can be, so that if you make a bad decision and then say, well, we weren't informed through the reconsideration process how things could work out. So that's just where that is. But again, that's on your side of the ledger. And if there's nobody else there is a lady here on reconsideration. Yep.
Do you want to introduce yourself, please?
Yes, my name is Barbara Dilla, and I live in Charlottetown. I have to commend the two speakers before me for their contribution, all of which I agree with, and so I won't repeat anything or anything of what they've said or go through any of that. I would like to say that the reconsideration process is something for a regular citizen, gives that regular citizen an opportunity to communicate with its city, with its own municipality on aspects that are perhaps less legalistic. Going through an IRAC appeal is an extremely daunting process, and it is not for the faint of heart. 3-day appeal Mr. Forbes referred to, I was a support person to the appellant. And the time and energy and effort and is astounding for a regular citizen to go through. And then to have to face a legal team where in some cases, unfortunately, it can become adversarial. And again, IRAC is a regulatory appeal board, and it doesn't go, as this gentleman said, to everyday local issues that matter more and could be looked at prior to an ultimate decision being taken. Mr. Forbes mentioned about pushback from developers. Yes, probably, but developers are not the only ones who live in this city and may not necessarily even live in this city. So just to make sure I don't take up too much of my time, or of your time rather, and mine, I came because I had thought that if there's a repeal of a process, that there might be something to replace it. I disagree that even IRAC's mediation process is a suitable replacement, because it's not a replacement, it's something else. And again, it's a very legalistic thing. It's very much about process. And sometimes when an individual or a community wants to request for reconsideration, it's not necessarily always something legalistic or procedural. As Janet said, communication is key. And examples have been given now and in the past of this letter that goes to property owners within 100 meters, information that's discovered after the fact or when things are already underway. So what I would like to read is the city's most recent community engagement framework, which I found this evening online. And I believe there are a couple of sections that are certainly worth reading that are in the introduction. So I presume that's the city, we are committed to meaningful and authentic engagement that will help us develop and deliver programs, projects, and activities that the community wants. The framework was developed to help clarify the engagement process. Offer clear direction on how residents can get involved and ensure that the purpose of engagement is evident throughout every step of the process. In a separate section, together as city staff, members of council, residents, businesses, and stakeholders, we share the common goal of building a better community. Who could be a better collaborator in this venture than the people who make up the unique fabric of our community? In another paragraph, local government is not a spectator sport. It is participatory, and a robust community engagement process is an integral component to an open and transparent government. Effective, consistent, and inclusive engagement will establish stronger partnerships, lead to more informed decisions, and provide the city with a reliable barometer of the public's opinion on upcoming projects and emerging issues. And I believe some of that was mentioned by these two other speakers. So in the name of democracy, I would like to either that the repeal be repealed or that there be an alternate possibility, whether it's part of disengagement process or something else. Thank you very much.
Thank you, Barbara. Thank you. Sure, go ahead. It's free. And we're not taking any time from you either. Your 5 minutes to stay. No, I'm short.
Yeah, he's short.
Take it with you. Okay, just introduce yourself. Address or municipality, whatever you wish.
My name is Mike Murphy. I'm also a resident of Southview Estates. And Jerry alluded to most of the circumstances there, but I want to say again, with respect to that particular situation, we were very fortunate to have the options provided to us under 315 of the Planning Act. So I missed a notice for this meeting in last Saturday's paper. And I just about missed it in this Saturday's paper, but my attention was drawn to it. So I am here. When I saw it, I had some questions. And I asked Jason Cody some of those questions, and he put the questions, or one question at least, to planning with respect to numbers. I still have more questions, but at the same time, I'm expected to respond in writing by noontime tomorrow. That's a pretty short time frame, given the circumstances and the notice I had of this meeting. So one of the questions I had for Jason, I'm going to go through them again because I'm still looking for the answers. I want to know how many reconsiderations were reviewed to come to the conclusion that 315 should be repealed. I want to know how many were reviewed. And I want to know that of those that were reviewed, how many of them met their criteria for a valid reconsideration? And I'm not going to go through them. They're all outlined in the section 315, what the criteria is of a valid consideration. So how many of those that were reviewed were accepted as valid considerations? I also want to know how many of them subsequently went to IRAC after being dealt with by the city. The question I have as well is that when council, for whatever reason, doesn't get the information or gets misleading information or on which they base their decisions on, and that information is inaccurate or wrong, is it the expectation of planning that the residents of the community should go out and hire a lawyer to correct that misinformation or missing information? And although the reconsideration processes may be very time-consuming, had that reconsideration not gone through for our subdivision, it would have affected that subdivision forever. Not time-consuming, forever. And I told you I was going to be short, and that's it. Thank you.
You want to take your water with you? Okay, thank you, Mike. Thank you, Jerry. Please come right up. Yep. Just introduce yourself, street, municipality.
I'm Catherine Morris. I'm here with Highfield Heights. Jan and I both put in the reconsideration, and I put in the appeal for the neighborhood. We received your email yesterday evening to my name, so I contacted IRAC today and asked for an abeyance for the reconsideration.
And, I apologize because usually the same people apply for the reconsideration, and I was going to correct my email tomorrow to your Ms.
Okay.
Roach in regard to,
Sure.
she's on the name of the reconsideration, but.
Yes.
But I did get
Yeah.
that email from Iraq, and thank you.
Yeah, and we're both here
Perfect,
for
yeah.
Highfield Heights.
Yeah, excellent.
And the gentleman that I was dealing with at Iraq was very surprised when I sent this information to him that this is being considered.
Oh, is that right?
Yes,
So I'm
yeah,
glad you did take that off, because under section 3.15 subsection 7, you can't have, as you know, a reconsideration and an appeal at the same time. So were you advised by the planning department to put your appeal in abeyance, or did you just get that information from IRAC?
when I received the email yesterday from Alex.
Yes.
I forwarded it to the gentleman that I was dealing with at Iraq, and he said, oh, you have to put in an abeyance.
Okay.
Yeah.
See, and again, this is why this process is, there's two people we're dealing with on this application. Ms. Roach sent the letter on the reconsideration. Most of them are always filed with an IRAC appeal, so I was waiting for the IRAC appeal to initiate the reconsideration process, and then when I got that yesterday, I think it was yesterday from IRAC, that triggered my email, but it should have likely been sent to
Yeah,
Ms. Roach.
just kind of more of an example that we need people to advocate for us when we don't know how things run, and that it's really important to have you guys to be able to look at things and not go the legal route. But that's all I have to say. Thank you for your time.
Thank you very much.
So just maybe,
Yes, you can follow up, Alan.
yeah, just on a couple of issues to the last gentleman's comments. In my time here, staff and the legal counsel have never recommended that it go to the second phase of it for you to review. Counsel, in his wisdom, decided to deal with Traynor Street. The other question, so that was one question. The other thing too is that, I'm a planner and we're paid to be in the middle of the process. So we're somewhat the referees. We are not there at the behest of the developers. We can handle the developers, but the developers also have certain rights. So there's two sides to the equation. This is one side of the equation and the developers are on the other side. You folks write through policy and the zoning bylaw, the rules of the road for the developers, which we hold them to. And if they deviate from that, they don't get permits, but if we refuse a permit, they're also at IRAC. So, these processes are to protect both sides of the equation. So, and it's in our interest because we're in the middle of it. We understand both sides of the issue. We don't take sides. And if we don't take sides, because the final arbitrator is IRAC, and they will say, staff erred, they made a mistake, and then you folks who pay us will be somewhat disappointed in regard to that we made a mistake in the process. Do we make mistakes on occasion? But the reality is that the IRAC process it's sworn testimony. It's a very different sort of a review process. And so at any rate, I believe in the process. It does take time, but so there, of all of those 28 type of applications that we received, I'm not certain. I've only been here 9 years. I've only can comment on the reconsiderations that we've had, but staff have never recommended that you folks go to that second phase. And the reason for that is then you're opening up a process that can be challenged by the other side in regard to you're dealing with those issues, but I'm not a lawyer. Mr. Hooley can help you out on that. But again, I just would like to put in the fact is we're the referees. We're not the decision makers. We're not aligned with the development community. If people saw or heard my phone on any given day from the development community, they're very they're in a rush to get permits, but they have to also do the things that are the requirements in the zoning bylaw. So that's my last comment, Your Worship, on that item.
Yeah. And Alex, just to clarify, IRAC doesn't have the final say. It can be appealed to the provincial Supreme Court
Correct.
or further, because that has happened to the city before.
Correct. And that could be the city. That could be the city can take IRAC to if they're really passionate about an issue. But anyway, that's the reconsideration process. The other one that we were dealing. Oh, sorry.
Yeah. Thank you very much, Alex. Just a question on the reconsideration process. How many of them would be not a legal issue? Like, or do they all turn into a legal issue, I guess?
The whole process and is under review. The process has to be run the same time every time. And if it's not run the same way every time, and if it takes a deviation, that's when there are issues. And that's when IRAC will spend a lot of attention. If you've always gone down for 3 years that road and you take a twist, they're going to probe that. Why did you do that? Why did council make that decision when historically they've made these other decisions this way? So, and the fact is that the zoning bylaw and the official plan is there to tell developers who are investing money, you must adhere to these regulations. And it's for staff to say, when you're putting in your application, you must adhere to these, or before we pursue taking your application forward, either a building permit or a development application. But we have to deal with both sides of the issue, and we're trying to be as neutral and as fair as we can in the process. Where, I can tell you equally, we're in a position, but lots of times neither side is happy with the planning department because we're in the middle of the process, and the development community either thinks we're slowing them down, and then the public think that we're not spending enough time informing them. So it's about getting the process right, whether it's reconsideration or any other component of the zoning bylaw. And, we follow that in regard to that. That's the direction in the OP, the official plan, and in the zoning bylaw as to what the expectation of this council is for development in this community. Thank you, Your Worship.
Thank you.
Councillor Twill, I'll just give you the big mic over here.
Want to thank you folks for coming out tonight, particularly here to talk about the elimination or proposed elimination of the reconsideration process. I think it was pointed out here tonight that the reconsideration process does give the residents an opportunity to address maybe some of the inaccurate information, misinformation, or information that council maybe didn't spend the time to deliberate or discuss. Not trying to be critical, but those are factors that can happen and have happened. So it's much more economically feasible for the constituency to have that opportunity for the reconsideration process, as opposed to having it eliminated, going to Iraq, and having to engage with lawyers, which it's cost prohibitive for some folks, a lot of folks, I should say. And I appreciate what you're saying, Alex, being under the gun from developers, threats of lawsuits and pressure. I understand all of that, but how do you balance that? Tell me how you balance that with the fabric and the quality of life in these respective neighborhoods that don't want an increase of traffic. I think tonight here, there's a figure of over 700 cars. They're talking about the proposed 700 cars that could take place. I know in another planning issue in Angus Drive, the traffic is enormous, just enormous because of a zoning change. And the residents that live in that particular section of Angus Drive are they've lost that quality of life. So I don't know. I understand, Mr. Mayor. I understand that. But I guess the point is that by eliminating the reconsideration process is a lost opportunity. It's a lost opportunity that you can never have back. Then, it's Iraq, it's lawyers, it's time consuming. Some people are intimidated. I know of one particular case where, Alex, a resident had filed the papers, had done their research, had to take on the city lawyers. She's not a lawyer. And she was totally intimidated. And guess what? She withdrew. It was the psychological impact and effect on that resident was enormous and overwhelming. It really was. So my question is, how do you balance that, Alex? I mean, you got developers, they have lawyers, city and its lawyers, and then the residents are in a very handicapped position. I would suggest very vulnerable and very precarious. That's my question, Alex.
Well, zoning rules happen in every city. I mean, it's a part of the planning process. The key thing is to write these documents as tightly as possible so the expectations are known in advance. The development community knows them as well. Because again, I mean, without the development community, you have no development. There's ways that if you don't want development, there's ways you can deal with that as well. But the fact is that you just have to balance those competing interests. But by sort of getting rid of the reconsideration process isn't going to slow things down. Like if you keep the reconsideration process and you make a decision, 95% of them all end up at Iraq. It's going to Iraq anyways. But my concern is that if you folks err, the whole process may have been fine in your attempt to correct it, and that's up to you folks. That's why you folks are here. In your attempt to correct something, you then may be the issue at Iraq and not the process to that point. So again, we have a lawyer and he's there to advise you on the legal aspects. I'm talking about generalities, but the reality is that these oversight groups, the Island Regulatory Appeals Group, is by its design put in place to put the discipline to this process. I know it's rigorous for the citizens, but it's the test and the information that has to be brought to bear when you're over there, your sworn testimony. So the process works. Thank you, Your Worship.
Okay. Any other questions? Sure, Jerry, you can follow up there.
Why would your department, why would council, and why would the city not want to review a decision that you made or they made that was based on misleading, was based on omitted information, or when new material evidence comes to light? Why would you not want to address that at the city level or at the department level?
Well, there was a process there. We did review that, but the reality is that recourse is that if you go to IRAC, you have to prove that information that's been alleged or on any development, whether it's your project or any of them. So you know, when you're over at IRAC, it's, and for anybody that's been there, it is very serious. You have to, we have to show every document we've ever produced on every email, every transaction that goes through here ends up over there. So they are the ones that determine if I know that was your concern in regard to Trainer Street. They may agree with you, but they may not agree with you. And as a result of that, they'll make a determination for council. So they are that's what the Planning Act was designed to do. They were the oversight body, not council. This is not a provincial requirement. It was something that was put in place by the city of Charlottetown to sort of deal with, in my humble opinion, a different issue. And now it's morphing into something that it was never intended to do. But these decision makers will answer your question, and the concerns of the residents, I report to them, and that's the way that the system works. It's just our recommendation based upon the past history with this part of the bylaw.
Jerry, it'll go back to the planning board for discussion of these amendments, and then recommendations will be made to the June regular monthly meeting of council. So you'll hear more. Councillor Tweel, you wanted to ask a question under section 35. You got ahead of you, the water law?
Yeah. Thank you.
Preamble?
Thank you. Yeah, I missed the opportunity. Alex asked a question about the water lot. So the buildings on the floating docks will have to adhere to the National Building Code. They
No.
will not have to.
Not have to.
Okay, so that's eliminated from the equation.
What it is that there's a whole other list of requirements that they must provide to us.
Okay.
So you need a structural engineer, validate all of the things a building inspector would typically do.
Okay, what about the requirements for water and sewer?
That is Richard's department has been all over that application, making sure that the hookups are appropriate. They're doing water testing down there. So that has been in place for some time, but it's now, as a result of the temporary use approval that was granted, is in a much more robust place.
And once you receive a permit, it's a permanent permit, so they don't have to come back every year and make the request for a permit. Is that correct?
So what the owners of the floating docks are on a temporary approval right now that you folks approved it in April. They will come forward with a permanent approval, but every year they need to get this, what we gave them this year. We have to go over that list every year because it's a seasonal type business. So all of those water connections are disconnected. We have to make sure that they're reconnected and everything is back to, the standard that it's supposed to be before they get going again.
Okay, thank you.
Okay, Mr. Forbes, where do you want to go next?
We'll go to home occupations. I feel like I'm in a game show. Let's go to home occupations for 20 points.
Oh, Jan, do you have another question?
Just one final thing on the reconsideration,
Yes.
talking about communication. So when the decision is made, how will we find out?
Oh, as I said, the planning board will meet next week, Mr. Forbes.
We won't be there on Monday, but I will send you an email tomorrow, the two of you, in regard to, we will be coming forward in July for reconsideration to planning board and council, and there's some information I'll send to you tomorrow in regard to the reconsideration process.
But you're,
Not our particular letter.
Oh.
I mean, this decision.
Okay.
How will
Okay,
the
sorry.
John Q. public find out?
Jan, it goes Monday, and then any recommendations from the planning board will go to council for the June regular monthly meeting, which is the second Monday of every month.
And the decision will be made at that meeting.
Then that's the final decision, to leave it in or to delete it.
Okay. Thank you.
Okay. Go ahead. Can you just take your mic there, please?
But we have to remember too that we may end up, if we don't have some of these questions answered by Monday night, particularly this gentleman here who had 3 succinct questions he wanted answered, it could be deferred a little bit longer, because you had 3 clear, distinct questions that you want answered. We want them answered too.
And we took them down. That's a good
Yep,
point.
we wrote them down.
Yeah.
Yeah.
So if they're not ready, Jerry, right, by Monday night, then we'll have to wait until, correct, Mr.
So
Chair?
it's all based on the planning board's information at our next meeting, which will be this coming Monday. So if the staff doesn't have those questions by that time and the planning board do not feel sufficient, that the answers haven't been answered, then there'll be a delay. If not, planning board will make their recommendation.
Just, Jerry, just use the mic. We just need it on.
I'm expected to respond by noon tomorrow. I don't expect I'm going to have those answers by noon tomorrow.
No, but you've asked the questions. And just as the Councillor Yankoff said, we have to have answers by Monday night when the planning board meets. Those answers are not ready for us, then we have to defer. They're being recorded. Yeah.
Send them anyway.
Okay. Okay, good. So Alex, what page are we on for the,
We're on section 5.9, home occupations. So all we're doing is adding a little bit to the definition under home occupations. The proprietor of the home occupation shall live in the dwelling in which the home occupation is located. And because of the STR regulation, and this also applies to general home occupation, and it shall be the proprietor's principal residence. So it's just that last part, and shall be the proprietor's principal resident, which is being added.
page 12, right, okay.
The next section is section 8.1, the zone tables. Every time we add a new zone to the zoning bylaw, it knocks all of the numbering out. This is a numbering issue, so it's just renumbering because of some changes in those tables. This is one that's near and dear to the politician's heart, the definition of election signs. So when this came through first, we had a definition. We realized that it had some limitations, but I think we've improved it. So the issue is that the two or higher levels of government, there's what's referred to as a writ. When the writ drops, which means the election starts today, the signs can go up. The problem when we brought this through initially was at the municipal level, there's no writ. So we had to put in some language to deal with, municipal government. So what we do know at the municipal government, it's a fixed date election. So what we do, it used to always kind of hover around 30 days, but all elections were different. In the case of, so we've changed the definition to say such signs can be erected on the day of the election period, when the election period begins, that's the higher levels of government, and shall be removed within 7 days following the date. In the case of a municipal election, the start date is defined to be the Tuesday 4 weeks prior to the fixed election date. So we know when the fixed election date is, it's on a Tuesday, and then so you back it up 4 weeks, it's 30 days, that solves that problem, or we are proposing that it solves that problem. It's up to you folks to make that determination. So that's that issue. Does anybody want to talk about election signs?
Any questions? Could you please we want you recorded here, Councillor Yankoff.
Just in, when you have in there, section 47.2.1, down below, when you say such signs can only be erected on the day the election period begins and shall be removed within 7 days. Shall is a pretty passive aggressive kind of a word. Should it not be must be removed? Because if you shall remove them, that doesn't really mean you have to remove them.
Shall in law means must.
Yeah. It's not me.
Yeah.
So shouldn't it be what must then?
No, shall is a legal term.
It is?
Yeah. So,
Okay,
yeah.
I stand corrected.
Yeah.
Thank you.
May would give you probably 14 days or 21. Shall, they better be down 7 days. No, I know, but there are two words they use, may or shall. We're using shall.
And it's in all zoning bylaws, may and shall.
Where's the, okay, the 4 weeks, the 4 weeks is,
So it's the end of the sentence that says, well, you're looking at your old report. This has been updated. So this will be in your new report. Yeah. No, new information. New information at the request of the mayor, the last time I brought it up, and he said that's not going to work. So we will put that in the report.
Reconsideration.
Yep.
Thank you, sir.
Okay, so then the next issue is subdivision requirements. And this has to do with, I got to get my glasses. So one of them is to deal with the number of subdivision plans. We used to have 8, we need 9. Then we are asking to remove section 48.3.4, an application for final subdivision approved or a consolidation of 2 existing lots into 1 large lot. It says may be submitted to the planning board by the development officer. We don't do that. So, and may, to your point, may is we may or may not. That is unclear in the zoning bylaw, so may isn't good. So we're asking to take that out. We don't send it to the planning board. Then there's from 8 to 9 copies of the plan. On the issue of 48.3.5, written notice to the property owner within 100 meters of the subject property is required to consolidate properties in the R3 and R4 zone, and then to provide further clarity. After 14 calendar days from the date of the notice, the application will be referred to the planning board, which shall consider the request and any comments received in response to the notice and shall make a recommendation to council. So it's just, it's giving the reference when those letters go out to the residents, they have an idea of when it's going to be dealt with at the planning board. So it's just providing further clarity.
Any questions?
Yeah, I think we're missing it for 1. Yep. No, you were correct on that one. Good eyes. Then the last item, your worship, is the fee schedule. And this one's pretty easy. We used to have the fees in the zoning bylaw for the zoning bylaw fees, but they're now in the new fee schedule bylaw. So some of that was hanging over in the old zoning bylaw. So we're just taking it out because all of our fees are referenced in the new fee bylaw. So that's it for the amendments. If there's any other questions, your worship, I'm here to answer them.
Any more questions from the public? Any questions? Councillor Twill?
Yeah.
Another question? Okay, sir.
Thank you. Alex, just a question on communications. One of the residents here tonight talked about, there was 2 ads in the newspaper. That's always been the standard procedure. I look out in the audience tonight. I know these are housekeeping matters, but we don't have a very big turnout. What are other possibilities in order to get the information out that council is having a public planning meeting? And there might be one of those items that are of particular interest to one of the communities throughout the city. We do advertise in the Guardian. I know that, and those are big, expensive ads. But what other methodologies are we not employing now that we could in order to get that word out?
Well, the problem is that those requirements, those notification requirements are in the Community Planning Act. If you want to change them so it's consistent across the province, you should be lobbying the province. The problem with everything we do has got to be the same every time we do it. So that's the problem with, extending a notice or doing a special notice. Then somebody says, well, you didn't send me a special notice. So that's how that's dealt with, but they're likely antiquated. I mean, I don't know how many people read the paper, but.
Have the service.
Yes, make sure I'm recorded. Do we still have the service notice announcement where residents can sign up at the city and then they get notification? Do we do? Do we put the notices out on that, Ellen? Yeah, but we didn't, through communications, used to have something where someone could register their name and they'd get like a notice. Okay, well, we maybe should do
should probably do
that.
We should probably do a communications blitz then to remind the public that they can sign up for that. I actually didn't even know about that.
But you just have to be careful on those notices, because if that's one of the big issues that Iraq pours all over. How did you do the notice? That's
Well,
all of that's.
It's just an
More notice, the better.
Yeah.
Okay.
But it's just, we just have to be consistent on the application of the notice.
It's up to the responsibility of the resident to sign up to receive notices. So if they don't, I mean, it'd be like Alana said, just to get the information out if they
Sure,
want to
and
receive
I-
it, in addition to everything else we're doing.
Yeah, I'm not even certain how that works myself, but we deal with our side of it. And if there's additional information that can be put out, it'd be
Alana,
great.
bring that up with your committee.
Mr. Forbes, as always, thank you very much.
Thank you, Your Worship.
Thank you for coming out tonight. I have to ask, any introduction of new business? Councillor Ramsey? None? Okay. Is there a motion to adjourn? Moved by Councillor McCabe, second by Councillor Ramsey. All in favor? Thank you very much. Merci beaucoup.